Good afternoon, sir.
Good afternoon.
Hi. Your case is at 9 o'clock, or not 9, 1 o'clock. So if you just want to hang tight, um, well, the judge will call your case then, okay?
Okay, sounds good. Thank you.
You're welcome. Good afternoon, ma'am. Can you hear me?
Yes,
Hi, what is your name, please?
My name is Kayla Brown.
Thank you. They don't want to. Good morning, sir, who just signed on. Can you hear me?
Yeah, I can hear you. Can you hear me?
Yes, I can. What is your name, please?
Ronald Webb.
Thank you. Good afternoon, Mr. Robinson.
Hey, Marianne.
How are you?
I'm well. How are you?
I'm good, thank you.
Good.
Miss Brown and Mr. Weber here. Do you need to speak to them before the judge comes out?
Yeah, that's probably a good idea.
Okay, I'll put you, do you want them individually?
Yeah.
Okay, all right. I'll move you to 7 and I'll move, Miss Brown to 7 also.
Marion?
Yes.
Hi, my office had submitted a conditional dismissal for the case ending in 0290. Do we still need to put that on the record, or it was submitted, I believe, earlier in the week?
I can ask my judge if she has that. What's the case number again, please? I'm sorry.
It is case ending in 0290, and it's Parkwood Manor versus Denisha Hardman.
Um. Yep, my judge just said it's already signed and off. Yep, it's not on the.
Perfect. Okay, thank you.
You're welcome.
Marianne?
Yes.
Okay, I took care of Ms. Brown. We're gonna have a consent on that.
Okay.
Just need Mr. Webb.
Okay. I'll get you in there.
Thank you.
Good afternoon, Mr. Morton.
Good afternoon, Your Honor.
Ms. Sprague,
Good afternoon.
good afternoon. My policy is about 15 minutes after the scheduled start time, so if Ms. Jones is not here by about 1:15, I'll call the case so you can get on with your day.
Thank you, Your Honor.
Thank you. Good afternoon, Mr. Robinson.
Morning, Judge, or good afternoon, Judge.
Were you ready with Ms. Brown or Mr. Webb?
Well, Ms. Brown and I have a consent.
Okay,
I
this is
don't,
230, I'm sorry.
for Mr. Webb, I did speak with him, but we don't have a consent. So.
Okay, this is 2303576 LT. This is Evergreen Town and Country versus Kayla Brown. Would you please state your names for the record?
Kayla Brown.
Good afternoon, Your Honor. Steve Robinson appearing on behalf of Evergreen Town and Country. The manager is also on Rick Baker.
I see him. The terms of the consent, Mr. Robinson?
Your Honor, total rent $5,485, court costs of $167 for a total amount of $5,652 to be paid on or before February 14th, 2024.
Not February 14th.
Thank you, Judge.
I mean, I'm happy to go back in time with you, Mr. Robinson, but
March 14th, Judge. Kayla, you knew that when we were talking, didn't you?
I did. It didn't click with me that we were saying the wrong date till right now.
were those the complete terms of your consent judgment, Mr. Robinson?
They are, Your Honor.
Thank you. Ms. Brown, you were here previously when the court played a video that explained the rights available to you in a landlord-tenant case.
I don't think so. I don't remember a video.
Do you remember receiving an advice of rights form in the service of the summons and complaint?
Yes, you're right. The very first one. Yes, ma'am.
Right. Did you have any questions about the rights available to you this afternoon?
No, ma'am.
And after speaking with Mr. Robinson, it's your understanding and agreement that a consent judgment will enter where you acknowledge owing past due rent of $5,485, that there's $167 in costs for a total of $5,652 that you will pay or vacate the property by March the 14th, 2024.
Yes, ma'am.
And ma'am, did you have any questions at all about the consent judgment or today's proceedings?
No, ma'am.
And because you appear by Zoom, there is not a signed consent judgment. Have you authorized or do you authorize Mr. Robinson to sign your name to a consent judgment with the terms we just placed on the record?
Yes, I do.
Okay, then Mr. Robinson's office will prepare a judgment with the terms we just discussed. He'll submit it electronically. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Robinson?
No, Your Honor.
Anything else, Ms. Brown?
No, ma'am.
Thank you. Good luck to you, Ms. Brown. You're free to go. You have a good afternoon.
Thank you. You as well. Bye, Mr. Robinson. Have a good day.
You too. Thanks, Kayla.
Thank you.
And then for 2303578 LT Evergreen Town and Country versus Ron Webb, sir, would you state your name for the record, please?
Ronald Webb.
Thank you. Mr. Webb, you've had the opportunity to speak to Mr. Robinson this afternoon,
Yes, I have.
and you have not reached an agreement regarding this non-payment of rent case.
But actually, I'd like to speak with you for a moment. I'm literally going through where I'm having payroll cards hacked into. I just got paid today a day early, and I was woken up by Gusto, these guys, and being informed that this brand new account was hacked into and $900 of it was fraudulently spent. I've been going through this now for over a year, almost a year now. I'm at a total loss. I make too much money for help. I've applied for help with DHS, but because somebody else was living here with me at the time, they keep turning me down. They've moved out. I just got a letter from them on the 24th. They need more information, which was submitted for help. I'm at a loss. I'm literally, Salvation Army just paid my electric. I've had my payroll account hacked into 3 times in 6 months. I'm at a total loss, and I'm gonna have to try and find a way to get a lawyer to help me. I make just a little, barely over the cap for any type of assistance through DHS and Salvation Army.
Mr.
Don't know.
Robinson, I'm sorry.
But yeah, I don't know.
Mr. Robinson?
Judge, I sympathize with Mr. Webb. I don't know what his issues are with his bank account or what needs to be done with that, but I don't think Mr. Webb is disputing the amount that's owing. So this is our second hearing.
No, I'm not.
What is the rent to
disputing.
retain possession, Mr. Robinson?
$7,224, court costs of $167 for a total of $7,391.
Mr. Robinson, were you, sorry, Mr. Webb, were you able to hear Mr. Robinson just now?
Yeah, I have it
Is
right
the amount
here.
of rent, is the amount of rent placed on the record correct?
It's not being disputed.
Okay, Mr. Webb, I remember when we were here before because you held up a couple of cards that indicated you've been a repeated victim of account hacking. And although the court sympathizes with you, if you don't dispute the rent, then there's no tribal issue of fact, and Mr. Robinson is entitled to entry of judgment in the amount $7,224 plus the $167 in court costs for a total of $7,391. I guess the court can make all kinds of suggestions about going to the police and putting hawk alerts on your accounts and all of that, but when we talked before, it appeared that you had already done that. I'm at a loss as to how to assist you.
Even Gusto's at a loss on how they got to this new card. There's 2-step authentication set up on it. I just literally got this card in the mail.
And you've gone to the police regarding all of these hackings and nothing?
I'm headed to the police station right after I get done with you, and I'm gonna show Van Buren all this stuff again. I'm being cyber hacked, and I don't know how to stop it.
Well, Mr. Webb, again, because you don't dispute it, Mr. Robinson will submit a judgment that contains the amounts we just placed on the record. He'll submit it electronically. I'll sign it and a copy will come to you in the mail. And I wish you good luck in your conversation with Van Buren Township Department of Public Safety. Take everything you have with them. Maybe they have some suggestions on how to avoid being hacked going further or to recover what was removed from the cards you just received yesterday, okay?
Okay.
Mr. Webb, good luck to you, sir. Have a good afternoon.
Thank you, Judge.
Thank you, Mr. Robinson. Mr. Katz, did you speak to Mr. Draper? I don't think so. I didn't see you leave.
I did.
Oh, that was fast. 2303-555 LT, Maxwell versus Michael Draper. Sir, would you state your name for me, please?
Michael Draper.
Thank you, Mr. Draper. Mr. Katz, how are we proceeding?
Your Honor, I did have an opportunity to speak with Mr. Draper. We did enter into consent judgment. There's currently a balance due of $3,508 of past due rent, $168 of costs for a total of $3,676. Mr. Draper understands he has until March the 8th to pay that amount, move out, or work something out with my client, providing him more time. He was advised MCR 4.201 and did authorize me to submit this to the court with his verbal authority.
Thank you. Mr. Draper, when you were here previously, do you recall seeing a video that explained the rights available to you in the landlord-tenant case?
Yes, I've seen the video.
And you also received a copy of the advice or rights in the mail when you were served with the summons and complaint?
I believe so.
Do you have any questions about the rights available to you in these proceedings?
I do not believe so.
And sir, you also heard Mr. Katz put the terms of the consent judgment on the record. Did you have any questions at all about the terms of the consent judgment?
No, he clarified them for me.
Okay. And you asked that the court enter a consent judgment that shows a total due of $3,676 that you will pay or vacate the property by March the 8th.
Yes, Your Honor.
Then Mr. Katz's office will prepare the consent judgment with those terms on it submitted electronically. I will sign it and a copy will be mailed to you at the address we have on record. Was there something else, Mr. Katz?
Nope, all set, Your Honor. Thank you.
Anything else, Mr. Draper?
No. No, Your
Thank
Honor.
you. Good luck to you, Mr. Draper. You're free to go. You have a great afternoon.
You as well.
Thank you.
Should have taken more time with him.
Why?
Well,
I
you were
looked down for half a
disappointed that I was
second. I didn't
so
even
quick.
see. And then just 1:30. Do you have something you want to do for the next 15 minutes?
Yeah, I'll put it on mute and shut the video off. Is that okay?
That's fine. Thank
Or do you
you.
want me to just leave all in total?
It's up to you. I just don't want you to feel as if you have to sit here, but if you at least stay in the session, you will see if
Yeah, no, I'm gonna put
Ms.
it. I'm gonna
Williams
keep it on.
appears.
Yep, sounds good. Thank you.
Thank you. Okay, Mary Ann,
Yes, ma'am.
you need to call Avery and tell him to get the shuttle bus ready.
Ready for what?
There is a Tater Tot Festival in Grand Rapids on May the 4th. I'm just saying.
I will call him right now.
It's a Saturday. That'd be a nice team building activity.
Tater tot. You know what? Anything for a party, right? Let's celebrate tater tot. I like that.
I'm a huge fan. Yeah, head over to Grand Rapids and see what we can get into. This is 23033636 LT Parkwood versus LaDawn Jones.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Thank you, ma'am. Today was the day and time scheduled for the adjourned hearing in this matter. When we were last here, Ms. Jones indicated that she was making application for rental assistance. The court, as of this morning, had not received a completed DC 539. Case was scheduled at 1 o'clock. It's now 1:15. Ms. Jones has failed to appear. How would you like to proceed?
Yes, Your Honor. My client had received the keys in the Dropbox last week. So at this juncture, we've already obtained possession. So we're simply requesting the money judgment.
The terms?
It would be damages in the amount of $7,821 and court cost of $233 for a total due and owing of $8,054.
Thank you. Ma'am, please submit the default judgment with those terms on unbased. The court will sign it and get it back to you as soon as possible. Have a good
Thank you,
day.
Your Honor. Your Honor, if I may, under Part 4, do you just want me to write that we have possession?
Yes, ma'am.
Okay, thank you.
Thank you. Two four zero zero one five nine LT Harbor Club versus Tamari Ford.
Hello, I'm here.
State your name, ma'am.
Tamari Ford.
Thank you. You've had the chance to speak to Mr. Morton this afternoon.
Yes.
Mr. Morton, how are we proceeding?
For the record, Attorney Ian Morton of Pallets Law on behalf of the plaintiff. The parties did speak and we've agreed to enter into a proposed consent judgment agreement. Rents retained are $4,158.65. Court costs of $190.24 for a total of $4,348.89. The payment date would be March 4th, 2024. I did advise Ms. Ford the fact that this agreement would not be final for 3 business days, the fact that she does have 10 days to appeal, as well as she did give me permission to sign her name to the proposed consent judgment agreement.
Thank you. Ms. Ford, do you remember being in this court session and seeing a video explaining your rights in this landlord-tenant matter?
Yes.
Do you recall receiving a copy of those rights with a copy of the summons and complaint?
Right.
Did you have any questions about the rights available to you in this landlord-tenant proceeding?
No.
Ma'am, you also filed a DC 539 with the court that explained that you had made an application for rental assistance. What's the status of that application?
As of right now, I don't have a status update. I did, file for one, but I haven't heard back anything so far.
So ma'am, after being advised of your rights and having the opportunity to speak to Mr. Morton, you wish to enter a consent judgment this afternoon that provides that there is $5,158.65 in past due rent, $190.24 in cost, for a total of $4,348.89.
Yes.
And ma'am, that you will pay this amount or vacate the property by March 4th, 2024.
Right. Yes.
And you authorize Mr. Morton to sign your name to that agreement.
Yes.
Ms. Ford, do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Mr. Morton will prepare it, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Morton?
No, Your Honor.
Thank you. Ms. Ford, you're free to go. You have a great afternoon, ma'am.
You too.
Thank you.
Your Honor, I'm not sure if the court wants to call the 1 o'clock default, or we can just do any defaults that come in totality. Was it with the other cases for my office?
Since you're here, I'm happy to do the 1 and then the 115s in here in about 10 minutes. It was 2303606 LT Holiday Woods versus Sean Wakus.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Holiday Woods.
Thank you. This matter was scheduled for a second hearing at 1 p.m. It's now 1:19 by this court's clock. Defendant has failed to appear. Mr. Morton, how would you like to proceed?
Your Honor, at this time, we would ask a default judgment for possession be entered. Rents retained are $2,467.53. Court costs of $187.70 for total of $2,655.23. And again, this is a non-payment of rent for possession only default judgment. And additionally, if the defendant shows up while I'm still here, I'll be more than willing to talk.
I appreciate that, Mr. Morton. Otherwise, the court will grant your request for default judgment. Please submit it through unbased. We'll sign it and get it back to your office as soon as possible.
Absolutely, Your Honor.
Thank you. Good afternoon, Ms. Williams.
I can go in a breakout room with Ms. Williams.
This is 2303559 LT Maxwell versus Williams.
Good
Could you
afternoon,
state
Your
your
Honor.
names for the record, please?
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiff.
State your name for me, please, ma'am.
Veronica Williams.
Thank you. The parties have had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, we did discuss this matter. We are entering in consent. It seems Ms. Williams has technically moved out, but she has not handed or relinquished possession. Currently, there's a balance due of $4,623. She understands that she either has to pay that amount or move out by March the 4th. If neither of those happens, she understands that a writ of eviction may issue. She was advised of MCR 4.201 and authorized me to submit this to the court with her verbal authority.
Is 4623 past
Oh,
due
I'm
rent
sorry.
and court costs?
I forgot to break it down. $4,455 of rent, $168 of cost for a total of $4,623.
Thank you. Ms. Williams, you were able to hear Mr. Katz just now?
Yes, ma'am.
And ma'am, when you appeared before, you saw a video that explained the rights you have available to you in this landlord-tenant matter?
Yes, ma'am.
And you also received a copy of the advice of rights with the service of the summons and complaint.
Yes, ma'am.
Did you have any questions at all about the rights available to you in this landlord-tenant case?
No, ma'am.
And after having the conversation with Mr. Katz, is it your understanding and agreement that a consent judgment will enter that shows that there's past due rent of $4,455, $168 in cost for a total of $4,623?
Yes, ma'am.
And you've authorized him to sign your name to a consent judgment that indicates that you will either pay this amount or vacate the property by March the 4th.
Yes, ma'am.
And Mr. Katz indicated that you are technically moved out, but you haven't surrendered the keys. Is that correct?
Yes, ma'am. I gave my keys to my mother, who's also the co-signer, the co-applicant on the lease, and she has my keys.
Okay. Okay. Ma'am, keys, equal possession. Keys need to be surrendered to the Maxwell, and you need to provide them with your forwarding address. Other than that, Mr. Katz's office will prepare a consent judgment with the terms just placed on the record. You will send it to this court electronically. I will sign it, and a copy will be mailed to you at the address that we have on record.
Okay.
Is there anything else, Mr. Katz, in this matter?
No.
Anything else, Ms. Williams?
No, ma'am.
Thank you. Good luck to you, Ms. Williams. You're free to go. You have a great day.
Thank you, you too.
Thank you. Thank you, Your Honor.
Thank
I think
you.
that's my
This-
last one. Enjoy the Tater Tot Festival.
I'll see you in a couple of weeks, sir. Have a good one.
All right, bye.
This is 2400164 LT. This is Harbor Club versus Lisa Johnson.
I'm not sure if the unidentified iPhone is one of the parties in any of the cases, Your Honor.
I was gonna take her into a breakout room, but we can ask her here.
I was gonna say, are you trying to move her? Ma'am, your name, please, with the white sweater?
Yes, Monica Washington. I'm sorry, I just got homework.
Miss Washington is a Holiday West case that was scheduled at 1:15. So I can speak with Miss Washington first, or we can do the defaults, Your Honor, whichever the court would prefer.
Dealer's choice, I'm here.
I'd say let's get the defaults out of the way, and then I'll go ahead and speak with Miss Washington. I think there's only one left, and that's the
The matter of Ms. Johnson was scheduled at 1:15, is now 1:34 by this court's clock. She's failed to appear. How would you like to proceed, sir?
Your Honor, at this time, we would ask for a default judgment for possession to be entered. Rents retained are $2,885.50. Court costs of $190.24. For a total of $3,075.74. This is a non-payment rent for possession only action, Your Honor.
Thank you. The court will enter a default judgment. Please submit it on base. Ms. Washington, you'll see an invitation to go into a breakout room with Mr. Morton, the attorney for the property. Please go there and speak with him. After you're done, you'll come back to this main session, okay?
Okay,
Thank you.
thank you.
Miss Washington, did you receive an invitation to move to a different room? I can't hear you right now because you are on mute though, ma'am.
Hello?
I
I
can hear-
muted it.
I can hear
Oh,
you.
you can hear me?
I can hear you now. So did you receive a notification to go to a different room?
No, it didn't pop up.
I'll move you into a different location. Let's see if you received this one. Did you see?
Okay.
Thank you, Mr. Morton. Ms. Washington? This is 2303-653 LT Holiday West versus Monica Washington. Would you please state your names for the record?
Yes, ma'am. Monica Washington.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Holiday West.
Thank you. Today was the day and time scheduled for the adjourned hearing in this matter. The parties have had the opportunity to speak. Mr. Morton, how are we proceeding?
Your Honor, the parties did speak and we did enter into a proposed consent judgment agreement. Rents retained for the month of February are $1,665.25. Court costs of $190.24 for a total of $1,855.49. The payment date would be March 4th, 2024. As long as that payment's made by that date, as I advised Ms. Washington, then this case would be resolved. Additionally, I did advise her that this agreement would not be final for 3 business days because she's not represented by counsel. The fact that she has 10 days from today's date to appeal, and she did give me permission to sign her name to the proposed consent judgment.
Thank you. Ms. Washington, were you able to hear Mr. Morton just now?
Yes, ma'am. I was.
Was everything he said true and accurate?
Yes, ma'am.
And ma'am, when you were here before, you watched a video that explained the legal rights you have available in this landlord-tenant matter?
Yes.
And you also received a copy of those rights when you were served with the summons and complaint?
Yes.
Did you have any questions about the rights available to you this afternoon?
No, ma'am.
Do you have any questions about the consent judgment that was just placed on the record?
No. No, I do have one question. It's just it kind of struck me right now. When this case was adjourned, because I was getting help from the state, I wasn't, at first it just said it was for $2,300 for December and January. I was just kind of confused how February got added in as well while I was waiting for the state to help pay, because the state ended up denying it because February was thrown on there. So that's why they end up denying it, because it was too much. And they said I didn't make enough to, be able to live here and pay that much. And I was trying to explain to my, hello?
I'm sorry, Ms. Washington, you were trying to explain to them what?
I'm sorry. I was trying to explain to my worker that it was just for the month of December and January, but she still wouldn't, help pay because they threw February in there. And I just thought it was for December and January, not February as well. Because originally it was only for December and January, but when I came back to court, February was added on, even though we adjourned to see if the state was going to help. February.
What happens when they filed the case, December and January were probably just due, but when the case was then scheduled for the first hearing, February was added to the ledger, even though it doesn't say it on the paperwork. And if we had gone into March, they would have been able to add March as well. But what the court will do is enter consent judgment with the
about how that worked. That's all.
Ms. Washington, I understand. I was going to suggest to you that after Mr. Morton's office submits the consent judgment with the terms just placed on the record, they'll send it electronically. I'll sign it. You'll get a copy in the mail. You may still want to reapply for assistance to see if it makes a difference that the amount is now lower because it's just the 1 month showing as due.
Okay. Well, I'll be able to pay you on Monday. Everything will be paid off on Monday.
Oh, and that's wonderful, ma'am. Was there anything else this afternoon?
No, that's it.
Thank you, ma'am. You're free to go. You have a great day.
Thank you. You too. Bye-bye.
Thank you.
Your Honor, I believe that's the last matter before the court of my office.
No, that's
No?
not the last matter.
No?
I'll see you in 2 weeks, I think.
Sounds wonderful.
Take care, Mr. Morton.
All right, may I ask one question, Your Honor?
Yes.
Were those from your adoring fans, or did you collect those figurines behind you, the heart figurines from some other location?
A friend of mine makes them.
Okay, nice.
And I know that she sees this from time to time, and so that's just a little wink and a nod to her.
No, they look, yeah, but I could tell they did not look like they came from a CVS or Target initially. So yeah, they look nice.
No, thank you. Take
Absolutely,
care,
Your Honor.
sir.
Thank you.
Billy Thiebert?
Yes, ma'am.
Your case is scheduled at 2 o'clock. I have not seen anyone from Mr. Levine's office. So if you sit tight, as soon as they get here, we'll get you connected with them and we'll figure out what we're gonna do this afternoon, okay?
Okay, thank you.
Thank you.
The person who just signed on with the phone number ending in 0813, can you hear me?
Yes, I can hear you.
Hi, what's your name, please?
Rochelle McCann.
Oh, okay, welcome back.
Hello. Hello. Oh, I think I'm
Yes, ma'am.
Oh, okay. I didn't know if I'm still on hold, right?
Yeah, your case will be, is scheduled at 2:00.
Oh, okay.
Good afternoon, ma'am. Can you hear me?
Yes.
No, Miss McCann, sorry, I'm sorry. I was trying to get someone else's attention.
Oh, okay.
Miss Morris, did you join there should be an invitation for you to join a breakout room?
Her audio's not on.
Oh, that's the problem.
Ms. Morris?
Hello?
Hi, ma'am. Staff is trying to get you to go into a breakout room. You should see an invitation or a button asking you to join a breakout room.
No, I don't see anything yet.
I'll try it again.
Thank you.
Pam, did you see the invitation?
No.
Mr. Devlin, Ms. McCann is here. Do you need to speak to her before your case is called?
Yes, Your Honor. Additionally, I am here for Ravitz and Robert Novak on Birch
Thank
Run,
you.
Marcella Thomas.
Good afternoon, ma'am. How are you?
Good afternoon, Your Honor. I don't know if you're talking to me, but good afternoon.
Yes, I was. I know you just signed in, but there are a few people already in your waiting room.
Okay, perfect. Thank you.
Thanks.
Your Honor, I'm all set with Miss McCann. Will be a dismissal.
Thank you, Mr. Devlin.
She's on-
And 240, I'm sorry.
She's on a phone. I don't know if she can pull back. Oh, there she is.
Hello?
2400250 Propel Property versus Rochelle McCann and April Calloway. Ms. McCann, Mr. Devlin has advised that this case is being dismissed. Do you have any objection to that, ma'am?
No.
The case is dismissed. You're free to go. You have a great day.
I'll e-file, Your
You
Honor.
too, thank you.
Thank you, Mr. Devlin. And as for Ella Thomas, my policy is 15 minutes after the scheduled start time. Give me a few more minutes and I'll call that matter so you can get on with your day.
Thank you, Your Honor. I'll spin around in my chair until then.
Hey.
I just need to talk to the doctor's handwriting.
Months of probation.
No contact with complaining victim
Or children.
or children. All
I
right.
don't, and I think it's his sister.
Okay. I've been up to the house. I know it. So, all right.
When I looked at it, I was like, yeah, this is gonna come back from somebody. I just, what,
I
was
know
it?
two other people before I came up. So
It's not, listen, this is not the first time that I've had that problem.
no, won't be the last either. Thank you.
Thank you.
Was it children?
It was children.
Huh.
First of all, I don't have the worst handwriting in this building, so let's stop pretending.
Your Honor, I have to state that mine is probably worse.
We have 1 second, but Mr. Devlin, you used to have, I think, a backdrop that looked like there were empty mustard containers behind you.
It's not a backdrop, Your Honor. That's where I am on Tuesdays. It is the Eastern Medical Supply Closet for a client of mine. It's a bunch of herbs and I guess tinctures and powders that are used in acupuncture and Eastern medicine. It's real.
And I'm guessing you've been asked about it quite a number of times.
Every judge I've been in front of. Usually it's the third or fourth appearance where they finally get the courage to ask me where the hell I am. When COVID first came.
I saw it months and months and months ago.
When you couldn't be in the same room as somebody else with a mask on, the way his office works, the medical office works, there's not a lot of doors. And so one of my only doors where I could have a mask off to be on court required me to be in a medical supply closet. So I lost my cool desk. I lost my cool office. Now I'm in a supply closet. I've been there for the last 4 years.
I knew there was a story behind it, and every time I saw it, I thought, next time I see him, I'll ask him. And your appearances with me have been so brief, I haven't had a chance to ask. But for 2400252 LT, I'm sorry.
I said I'm at home today.
Oh, lucky you.
Well, my kid has influenza, so that's the reason.
Oh, boy. Birch Run versus Ella Thomas. This case was scheduled at 2 o'clock. It's now 2:15 by this court's clock. Ella Thomas, no response, and there's no one in the breakout rooms by that name. There are no unidentified persons. Mr. Devlin, how would you like to proceed?
Your Honor, Adam Devlin, P 72877, appearing for the plaintiff, standing in for the attorneys of record, Lee Ravitz and Robert Novak. We ask for a default judgment to enter.
Do you have the terms of that judgment, sir?
I do, Your Honor. $2,101.25 in rent, $170.54 in costs, totaling $2,271.79. Writ dated the 4th of March.
Thank you, sir. Please submit by on base. The court will sign it. Anything else this afternoon?
No, Your Honor. I'll call his office to e-file.
Have a good day.
You too. Bye.
This is 2400226 LT Willow Country Estates versus Timothy Shepherd.
Good afternoon, Your Honor. Douglas Swadish appearing on behalf of the plaintiff.
Good afternoon, Mr. Swadish. I hope that we were going to have a good resolution of this matter. Remember the last time we were here, you were trying to work something out with the person occupying the property. Case was scheduled at 2 o'clock. It's 2:16. How are we proceeding?
So my understanding from my client is there have been conversations and agreement was reached on terms for the occupant going forward. However, I still need a default judgment against the named lessee, Timothy Shepherd, as this was a non-payment of rent. In theory, he could tender the large amount of rent owed and thus would have the right to retain possession. So the new lease agreement will not be signed between my client and the occupant until after March 4th. So what we'd be asking the court to do would be to enter a default judgment for possession only against Timothy Shepherd, the named lessee. But it would be, I guess we would dismiss without prejudice the claims against the, I'm not entirely sure how to word it, where I get what I need for the default judgment without putting I'm trying to do the right thing by the lessee. I know the occupant. I know she's not here now, but I think she understands that she has an agreement with our landlord for her to continue to occupy it. So I can submit a dismissal as to Amber Shepherd, the occupant, separate from a default judgment against Timothy Shepherd, or if we could note something in the other orders that the judgment doesn't pertain to her, that would be fine with us.
I think it would be better to place it in the further orders of the judgment. My
Yes.
concern is if you do it as a dismissal, somebody will read dismissal and not pick up a separate judgment.
Yep.
So as for Mr. Shepherd, what are you showing as past due rent?
So we're asking for, this is possession only. The past due rent is $18,100.
Okay. Mr. Swadish, if you will prepare a default judgment submitted by on base, there are already earlier notes in the file that indicate that Ms. Shepherd had been here and had some conversation with you. So if you address her in the further order, I think that will suffice. Is there anything else in this case?
That's it, Your Honor.
Thank you.
Thank you, Your
And
Honor.
that's it for you this afternoon. Have a good day.
That is, Your
sir.
Honor. Thank you.
This is 2400217 LT Huron Estates versus Billy Thiebert. May I have your appearances, please?
Laura Kluber, Your Honor, on behalf of plaintiff.
Billy Thiebert.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. Parties have had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, I have had a chance to explain Ms. Thiebert's rights, and we have agreed to a consent judgment with rent owed in the amount of $2,338.95, court costs of $190.88, for a total of $2,529.83, with a writ date of March 4th, 2024. And she has given me her permission to sign on her behalf.
Thank you. Ma'am, you were able to hear the attorney just now?
Yes. Yes, I was.
Was everything she said correct and accurate?
Yes, Your Honor.
When you were here before, ma'am, did you have the opportunity to review the video that explained the rights you had available to you in this landlord-tenant case?
Yes.
And did you receive a copy of those rights in writing with the summons and complaint when they were served?
Yes.
Do you have any questions regarding your rights in this matter?
I do not.
Do you have any questions about the consent judgment that was just placed on the record?
No, ma'am.
And ma'am, the court will grant the request for entry of a consent judgment. The attorney's office will prepare it, file it electronically. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of Huron Estates?
No, Your Honor, thank you.
Anything else at all, Ms. Thiebert?
No, Your Honor.
Then ma'am, you're free to go. You have a good afternoon and good luck to you.
Thank you very much.
Thank you. We have one failure to appear in 2400187 LT Huron Estates versus Wendy Augustinus that was scheduled at 2 o'clock. It's now 2:28 by the court's clock. Ma'am, how would you like to proceed?
Your Honor, at this time, plaintiff wishes to proceed via default judgment with, this is possession only with rent to retain in the amount of $2,501.07, court costs of $190.88, for a total of $2,691.95, with a requested writ date of March 4th, 2024, Your Honor.
Thank you. Please submit it by on base. Court will sign it. Were you finished with Ms. Jones, Morris, and Mr. Walker?
Everyone is complete.
Oh, so let's get them back in this main session.
I'll move them.
Thank
you, Mary Ann. This is 2400265 Trilogy versus Justin Walker. Mr. Walker, unmute yourself, sir. Turn your video on and state your name for the record, please. Or maybe not. Let's try 2400238 LT Huron Estates versus Lanika Jones.
That is me, and good afternoon.
Good afternoon, ma'am. State your name and turn your video on, please.
All right. Legally, my name is Lanika Jackson, but they probably have it as Jones. I'm divorced.
Thank you. Ma'am, you had the opportunity to speak to the attorney for Huron Estates this afternoon?
Yes.
How are we proceeding, Ms. Karabi?
Your Honor, we have no tribal issue here other than she is requesting the writ date to be extended until the 7th. And I have no authority to extend it, so it is up to your discretion to extend it until the 7th.
What is the rent to retain possession, ma'am?
$2,645.84. Court cost of $181.68 for a total of $2,827.52.
I'm sorry, 27 and
$2,827.52.
Thank you. Ms. Jackson, were you able to hear those dollar amounts just now?
Yes, ma'am.
And ma'am, do you agree and admit that there's $2,645.84 in rent due and owing?
She said 2,800.
Yes.
That's the total, ma'am, but for the rent part, the rent is 2,645.84.
Yes, yes, ma'am.
And
I
then,
agree.
and then there's cost, that's okay. There's cost of $181.68 for a total of $2,827.52.
Yes, I agree. That's the total amount.
Thank you, Ms. Jackson. Inasmuch as you admit and agree that the amount of rent claim due and owing is accurate, there is not a tribal issue and plaintiff is entitled to entry of judgment as requested. The statutory period is 10 days from entry of judgment, which would be March 4th, ma'am, and the attorneys indicated that you're asking for an extension to March 7th.
Yes, and Judge, if you would hear me out so kindly, the reason why I asked for that is because I get paid on the Thursday of the 7th. That's why I asked, can it be to the 7th?
You get paid and you'll be able to remit payment or give payment to the landlord on that date, on the 7th?
Yes. Yeah, for the full amount.
Ms. Jackson, if the 7 works for you, then Ms. Kohlrabi will put it after hearing a judgment with a pay or vacate date of March the 7th. She will submit it to the court electronically. I will sign it and a copy will be mailed to you at the address we have on record.
Okay. So that
Was
means
there anything else?
that I get to the 7th, Judge?
Absolutely. Yes, ma'am.
Thank you. All right.
I'm sorry if I didn't say it clearly enough for you.
All right. I appreciate it.
Anything else, Ms. Jackson?
No, that'll be all.
Good luck to you, ma'am. You have a good afternoon.
You too. Thank you.
Thank you. In 2400259LT Trilogy versus Nicole Morris. Please state your name.
Nicole Morris.
Thank you, Ms. Morris. You had the opportunity to speak to the attorney from Trilogy this afternoon.
Yes, ma'am.
Ms. Kohlrabi, how are we proceeding?
Your Honor, the parties have agreed to a consent judgment in this matter for possession only, rent owed in the amount of $3,831.49, court costs of $181.68, for a total of $4,013.17 with a requested writ date of March 4th, 2024. And Ms. Morris has kindly given me her permission to sign on her behalf.
Ms. Morris, were you able to hear the attorney just now?
Yes, ma'am.
Was everything she said true and accurate?
Yes, ma'am.
Ma'am, when you appeared originally in this matter, you saw a video that explained your legal rights in this landlord-tenant case.
Yes, I did.
And you received a copy of those same rights in writing when you were served with the summons and complaint.
I did.
Do you have any questions about the rights available to you in this landlord-tenant matter?
No, ma'am.
Do you have any question at all about the consent judgment that was just placed on the record?
I'm not sure what a consent judgment is.
It's your agreement that the amount due and owing in this matter, including court costs, is $4,013.17.
Yes, ma'am. Yes, I do. I agree with that. Yes.
Okay. Then, ma'am, what the court will do is have the attorney's office prepare a consent judgment with those terms on it. They will submit it electronically. I will sign it, and a copy will be mailed to you at the address we have on file. Is there anything at all, Ms. Morris, before we conclude this case?
What should I do about the SER form? Should I resubmit that or just have everything in by the 4th?
What do you mean resubmit it?
Because I talked to my worker yesterday. Her name was Miss Hill, and she said I should have got paperwork that the first one that I submitted was denied, and she said it was probably denied because of the amount, and she wanted me to resubmit it.
Oh, then yes, definitely. You can always reapply for that assistance.
Okay. Okay.
Was there anything else, Ms. Morris?
Nope. I just need the documents from the court so I can submit it. But I am prepared to be paid up by the 4th.
As soon as we get them, I'll sign it, and then court staff will mail it out to you. Okay.
Thank you, ma'am.
You're very welcome. You have a good afternoon.
You too.
2400265 Trilogy versus Walker. Justin Walker. Ms. Kohlrabi, I've sent requests to Mr. Walker there we are.
I'm sorry. I don't know
State your
why
name
the
for me,
buttons wasn't
sir.
working. Justin Walker.
Thank you, Mr. Walker. You had a chance to speak to Ms. Kohlrabi this afternoon?
Yes.
Ma'am, how are we proceeding?
Your Honor, the parties have agreed to a consent judgment in this matter for possession only with rent to retain in the amount of $3,485.09 plus court costs of $181.68 for a total of $3,666.77 with a requested writ date of March 4th, 2024. I did have a chance to read his rights and he did give me permission to sign on his behalf.
Thank you. Mr. Walker, when you were here before, you had a chance to see a video that explained the rights you have available to you in this landlord-tenant case.
I did not.
You did not see the video?
No, I did not.
Did you receive a copy of your rights in a, when you were served with a summons and complaint in this matter?
I was. I seen that. Yes.
Do you have any questions about the rights available to you in this landlord-tenant case?
No.
You heard the attorney place the terms of a consent judgment on the record. Do you have any questions about the terms of that consent judgment?
No.
Then, Mr. Walker, the attorney's office will prepare a consent judgment, file it with the court. The court will sign it. A copy will be mailed to you. Did you have any questions at all about today's proceedings or your rights, sir?
No.
And Mr. Walker, that concludes this matter. You're free to go. You'll get a copy of the judgment in a few days.
All right. Thank you.
Thank you, sir. And that concludes this court's docket. We stand adjourned. Thank you, ma'am.
Thank you, Your Honor. Have a great